word about CFAR. CFAR, Civil Forum for Asset Recovery, is an NGO based in Berlin, which was founded in 2015 with the purpose to support civil society to make asset recovery processes more transparent and accountable. And we have been engaging quite a lot since 2019 on anti-corruption sanctions. I think Lucia can tell you a bit more about this. She's been leading this. And yes, I thank you again for being here, and hope you have a nice webinar.
Thank you so much, and welcome to people joining in. Hello, Tatiana. Just a little hello also from me before I hand over to our great panelists. My name is Lucia Cizmaziova, and I'm a project coordinator with the Civil Forum for Asset Recovery, and I focus on research and policy around new tools for asset recovery, which include also sanctions. And I see that there are some familiar names here that joined the event. And some of you also joined our previous event in May or other webinars where we already started to explore the link between sanctions and asset recovery. And we were doing so in the past, especially in relation to the sanctions imposed by the European Union on the deposed elites from Tunisia, Egypt, and Ukraine. And you also probably know that almost no successful recovery of assets has happened in these cases, despite the recovery intention being there from the start. And we have discussed how the imposition of asset freezing sanctions is a political process distinct from judicial processes of investigating and pursuing illicit funds. But despite these being two distinct processes, sometimes the recovery of frozen assets is expected, if not in all, then at least some of these cases of sanctioned assets, such as at the moment in the case of Russian assets, or, for example, the sanctions imposed on Tunisian funds, which, by the way, were actually almost completely lifted a few days ago without any recovery gains, and thus can be regarded as a failure. And so to prevent these failures, I think we can agree that we need to make the links between sanctioned asset and recovery clearer. And also because of the ongoing war in Ukraine, there is both the urgent need and the opportunity to do so via existing tools that we already have, but also to come up with some new initiatives to make the links between sanctioned assets and their recovery clearer. And so, as we know, investigating and recovering illicit assets is not an easy process, and there are many challenges standing in the way, in the center of a balanced recovery action that is both quick and legally sound. Some that might be echoed in the discussion later, for example, the lack of political will, the inadequate resourcing of law enforcement agencies, but also the need to establish underlying criminality that enables confiscation, and also, for example, the financial secrecy hampering even the tracing and investigating some of these assets. And so the challenges are many, but in this event, we would actually like to focus on the opportunities and the opportunities for confiscation of sanctioned assets, and therefore we will approach some of these challenges through this lens, and through the lens of some of the new initiatives and changes that unfolded in the aftermath of the Russian invasion of Ukraine, with the focus on developments in France, the United Kingdom, Ukraine, and the European Union as a whole, but we might touch on other jurisdictions as well. And in terms of the format, please note that the event is being recorded and that we will have 2 rounds of panel interventions, with each speaker having around 5 minutes. And there will be focus into two blocks. First, we will introduce the developments in the field that occurred after the Russian invasion, transitioning to the introduction of current activities and highlighting how these efforts react to the challenges that we identified in the past. And in the second round, we will discuss some of these initiatives in a bit more detail. So there will be a time for Q&A at the end, but please do post questions in the chat throughout, and then we can react to them as they come also in the second round of interventions especially. So having said this, I stop here and I introduce briefly our panelists. Warm welcome to Sarah Brimboeuf, the Head of Advocacy for Illicit Financial Flows at Transparency International France. Sarah is one of the leading figures responsible for advocating for measures against grant corruption and illicit flows in France. And she specifically, for example, worked on the restitution of the so-called ill-gotten gains cases, or the bien mal acquis. And on behalf of TI France, together with other organizations, she has also been party to civil litigation cases, which she will also tell us more about today. So welcome, Sarah. We are also very happy to have Pierre Minoves, policy officer from the recently established Freeze and Seize Task Force at the European Commission. And Pierre is an expert on the European criminal law with experience both from the European Commission, but also the European Parliament. And he's stepping in for his colleague Peter Csonka, who you might have initially seen on the agenda. So thank you, Pierre, for joining us. Then we are also very happy to have Maria Nizero, the research fellow from Royal United Services Institute, or RUSI. Maria has been studying the UK economic crime landscape and asset recovery with a focus on sanctioned frozen assets and proceeds of kleptocracy for a while. She has also been doing this at RUSI and elsewhere, and she's currently completing her PhD in International Public Law and International Relations in Barcelona. Thank you, Maria. And we also have Tatiana Shevchuk, the asset recovery expert at the Anti-Corruption Action Center in Ukraine. And Tatiana has a wealth of research and advocacy expertise in the area of asset recovery and anti-money laundering, with a focus especially on new tools and enhancing cooperation between governments and civil society in these spheres. And Tatiana has been sharing her expertise with us since after the Maidan revolution in Ukraine, and we are grateful for her to do so also now in these terribly difficult war times. So thank you, Tatiana, very much for joining us and for continuing your work with ANTAC. And so if I may, I would start here and let you to explain a little bit how are things with ANTAC and how things have changed after the Russian invasion in the anti-corruption, in the landscape of anti-corruption organizations, but also anti-corruption agencies in Ukraine. And then we can get to some of the more detailed policy and legislative changes in the second round. Thank you.
Thank you, Lucia. A small disclaimer, I don't have electricity, so I'm on mobile connection. So when I drop off, please bear with me, I will return. We at Anti-Corruption Action Center, we're working on the issue of anti-corruption sanctions for 8 years already. And we've seen how the landscape is changing and how the instrument is used. Of course, one of the biggest issues is sanctions and asset recovery was kind of competition or discrepancies between the political process and the criminal law justice process. And most of the problems, most of the issues were fulfilled when the expectations from sanctions were much higher than the state agencies or judicial systems could deliver, both in the countries of origin like Ukraine and the destination countries like the European Union countries or the United Kingdom. When the war came and the full-scale Russian invasion began, the governments, the first resource they started to use was sanctioning, and it's quite a new area for sanctions. Is not to stop kleptocracy, but to stop the crime of aggression and protection of world order with such an vague instrument as sanctions. This needs to review how we see sanctions. First and foremost, personal sanctions. We should understand this is not the pure mechanism of preventing or helping to prosecute white-collar crime, especially in terms of Russia. Because we need to rethink how we see corruption in Russia. And that will affect how we see sanctions and help us to make the instruments work better. Because corruption in Russia is not just a white-collar crime. It's not the trans-border crime which spills over to the other countries. This is the instrument of influence. This is instrument of aggression as well, because Russia for a long time was weaponizing corruption and no one was doing anything about it. Ukraine was one of the targets for that as well, but we see there a lot of influence of Russian corruption in other countries as well. When we see this corruption as instrument of a state instrument of aggression, we should change their attitude to sanctions as well. It's no longer a pure criminal story. It's no longer the story of preventing corruption.
Tatiana, I think we lost you there.
Or dirty money getting to your countries.
Hello? Okay, you're back. Or? No, okay. I think as Tatiana mentioned, she might drop off. She actually really did. So let's, I think while she joins, let's move on to another speaker, even though it was quite a fascinating discussion. Tatiana, we have you back. Do you want to continue and finish your thoughts? Unfortunately, I think the connection is not good at this moment. So I think while we reestablish the connection with Tatiana, let's move on. Okay, one more. Tatiana, can you hear us?
Yes, I can hear you. At what point did you lose me?
So you were saying about the corruption as a Russia's state weapon, and then it sort of disappeared.
Yeah, sorry. So we, in our approach to sanctions, we need to see it as not fighting the kleptocracy per se, but fighting the kleptocracy, which is a national security issue. That makes the use of sanctions at one point harder because it elevates the level. But on the other hand, we do not need to prove all the criminality, the illicit origin of funds, etc., and move on with more complicated sanctions and more stricter measures to their perpetrators.
Okay, thank you very much. I think this is something we should definitely get back to. And I would be very interested to hear the opinions of other panelists on this. But firstly, let me pass on to Sarah from TI France to introduce some of the sort of discussions and changes and new initiatives that were happening in France in relation to sanctioning Russian, but also other foreign assets of illicit origin. Thank you, Sarah.
Thank you very much, Lucia. Just to give some elements of background for France, as several other Western democracies, just a couple of weeks after the Russian invasion, our French Ministry of Finance announced its willingness to not only track down the assets, the Russian assets, but not only freeze them, but also seize them. He announced it at the radio and was heard, and his meanings by doing so, by saying that, was, he was clearly announcing that they were linking the Russian PEPs and or to illicit money. And so he announced that in early March 2022, but after that, nothing happened, and politically, they just changed their mind, perhaps, and just focused on the sanction per se without mentioning the fight against corruption again. So this is why Transparency International France decided to jump in and to file its own criminal complaint to push, to force the launching of an investigation. So we filed a criminal complaint in May 2022. And we targeted several Russian PEPs and oligarchs. We did our own investigation with the help of several investigative journalists. So we filed this criminal complaint, and then in July 2022, the French public prosecutor announced that he launched a criminal investigation. So it's not. We know that this is not a game changer, and we just focused on a handful of foreign PEPs and oligarchs. We targeted 5 of them, but we wanted to do so to prove, to demonstrate that it was possible to also use the criminal path to track down, to identify, and to seize those assets. And we also had in mind another idea, which was not only focusing on sanctioned individuals, but also targeting individuals that were not in the sanction list, because we all know that sanctions are a political tool, and they are a means of pressure to stop the war or to pursue those diplomatic interests. But we know that some individuals that they appear in the scandals of the Pandora Papers or on the Panama Papers have been linked to corrupt schemes or corruption-related offensive schemes, but are not in the sanction list. So this is why we wanted to have a mix of sanctioned individuals and individuals that were not on the sanction list. And I will stop there, but we also based our criminal complaints on an interesting tool that exists in France since 2013, which is the presumption of money laundering. And this is something we would like to advocate, and we would like to share it with colleagues from other countries, because we think that it could be a good leverage for targeting corrupt assets, kleptocrats' assets, in an easier way than the one that we are pursuing right now. So the presumption of money laundering is a rebuttable presumption, and it basically reverses the burden of proof. So the prosecution does not have to prove the illicit origin of the funds, does not have to prove the whole corrupt schemes. But when the prosecutors or investigators face complex financial or judicial structures that have no clear licit means, licit purpose, they ask the defendant to prove that the structures have a licit purpose. And if the defendant cannot demonstrate it, then he can be convicted for money laundering. So basically, it means that we can beat the corruptors and the money launderers at their own game, because the more complex the structures they put in place, the more the easiest it is for the French prosecutors to reverse the burden of proof. And I will stop here, but this mechanism, as I was saying, is almost 10 years old. It was not used a lot in France because prosecutors, investigators were not that used of it. They needed to learn how it worked, etc., etc. The mechanism was reviewed by the French Judicial Supreme Court, the Cour de Cassation, which not only confirmed the whole this mechanism, but also strengthened it by articulating it with another mechanism, which is the standalone character of the money laundering offense. So not only the prosecutors can reverse the burden of proof, but they don't have to prove together all the elements of the predicate origins. So this is really a powerful tool. I know that it sticks into the criminal avenue, but we think it's not a game changer. It's not a silver bullet mechanism, but it can really change the way we could recover Russian PEP's assets right now.
Very interesting. Thank you, Sarah. And let's get back to that as well in the second round in a little bit more detail, and maybe look at some of the cases where it was successfully applied to, so we can understand it better and how it might be applicable to other jurisdictions. And let's move on now to hear about developments in the UK from Maria. Because we know that before the UK left the European Union, it was probably the most active member in the area of sanctions, but not so successful either in terms of recovering the assets that were under the sanctions or outside, for the matter of fact. So Maria, can you please explain to us the developments this year, and what are some of the opportunities that we are seeing in the United Kingdom?
Thanks, Lucia. Can you hear me? Yes. Okay. To say that they were not being successful in terms of asset recovery, that's an understatement of how bad the situation was, especially when dealing with sanctioned assets. So I think that in the UK, the first thing, there was obviously an unprecedented response in terms of sanctions that were, placed on individuals and entities linked to, especially after the invasion by Russia of Ukraine. So that has been definitely an unprecedented response. We've seen much more attention in terms of what not just politicians, but also policymakers, the public, the media, how much attention they were paying on the matter of moving from freeze to seize, which in a way it has highlighted a series of issues. So first of all, the difference, the stark difference between what was before the invasion and then what happened after. Before the invasion, there was very little to no interest in pursuing any assets related to kleptocracy. We had, regardless of the sanction matter, we had some mechanisms such as the unexplained wealth orders that had been trialed. They were introduced in 2017. They were used, I think, 4 or 5 times, and most of the time they were unsuccessful. And due to the high costs that were resulting from these unsuccessful cases, there was a sort of reluctance in a way by law enforcement agencies to actually, go after assets related to individuals, alleged kleptocrats or the oligarchs as well. So we see the first big difference. First there was not really an understanding even of how important it was, and what Tatiana said in her presentation about the national security threat that was represented, by these assets in the UK and elsewhere. There was very, very little understanding. So what happened after the invasion of February 24th, I think that conversation started, happening in the UK. We saw some reforms, for instance, the unexplained wealth orders that I previously mentioned. There was a reform to the regime with the Economic Crime Act that came out, I think, in March this year. It feels like a lifetime ago. Okay. And so that introduced some amendments that were welcome, but obviously could go so far, mainly because most of the challenges that we have discussed, even during our previous meeting in May, it was basically very difficult to build the case against kleptocrats, mainly because of lack of evidence and dealing with not even an uncooperative jurisdiction, a proper hostile jurisdiction, which is Russia. I think that another thing that's very important to highlight here is that most of the sanctions that were imposed after the invasion, they were geographic sanctions. So they were not anti-corruption sanctions. Most of the individuals that are currently, supposed oligarchs and they are linked to the Kremlin, they are sanctioned because of their connection to the Kremlin regime and to the actions in Ukraine by Russia, but not because of corruption. Those are not anti-corruption sanctions. I think we have very, very few individuals currently under anti-corruption sanctions. So there have been, these sort of two conversations going on without necessarily understanding that, first of all, sanctions and asset recovery are two completely different mechanisms. Sanctions are a very political tool. Asset recovery requires, as you said at the beginning of your introduction, it requires a sort of few process, rule of law compliant proceedings. So that was very difficult for people to understand initially. And then the second discussion was, okay, so if we were to actually use sanctions as a tool, as one of the many tools that we have in the arsenal to fight illicit finance, well, then we have to make a distinction between geographic sanctions and anti-corruption sanctions, because they're trying to achieve two completely different goals. So I think that is what happened in the UK. You had potentially a lot of policymakers within different departments. We had Treasury working on one side, we had Home Office on the other. And then I think we came to the realization, also seeing what the EU was doing, that everybody was trying to pursue a different goal concurrently. So some wanted to go after the original corruption, some others just wanted to link it to the aggression to Ukraine, which albeit being a matter of national security, that was not linked to the initial corruption that the oligarchs were supposedly guilty of. So that was, I think, the moment of realization that we were working all on the same topic, but with a different goal and with a different understanding of the matter. Now I think that there is much more interest in seeing whether sanctions can be used as just a tool, as a starting point, as a useful starting point, or whether we should amend our asset recovery frameworks and much more in line, for instance, with what has been done in France, other countries. I enjoyed the fact that Tatiana mentioned again the national security matter, because we saw in other jurisdictions such as Switzerland, where some parts of the legislation, or even Italy, where they see, the matter of corruption and illicit finance in general as a matter of national security or as a social danger to society. But that is linked to our asset recovery frameworks, our proceeds of crime acts, and not necessarily to our sanction laws, which is SAMLA, the Sanction Act in the UK. I think that finally now that there is this sort of understanding that sanctions are a useful way to stop more dirty money coming into the country and to ground the oligarchs, in the meantime, more them to our harbors. But if we were to go further with asset recovery proceedings, that's when we should be thinking of amending potentially our Proceeds of Crime Act, or coming up with new legislation that tries to link the two.
Thank you so much, Maria, for the great overview. And now moving on to hearing from the sort of EU-wide perspective, I would like to pass on to Pierre. Can you please tell us from your perspective, from the perspective of the Freeze and Seize Task Force, what kind of challenges have you been focusing on, and what do you see as some of the opportunities going forward?
Yeah, First of all, thank you for having invited me, and I think it's very interesting what said Ms. Nizeo about the fact that we need to focus on asset recovery, because like the EU has been doing that by proposing a new directive that I'm going back to present in the coming minutes. But I think first it's important to focus, just to explain. So what's the Freeze and Seize Task Force? So the Freeze and Seize Task Force was set up by the European Commission to ensure the efficient implementation of the EU sanctions against listed Russian and Belarusian oligarchs across the EU. The Freeze and Seize Task Force works alongside the newly established Russian elite proxies and oligarchs repo task force, under which the EU operates together with the G7 countries such as Canada, France, Germany, Italy, Japan, the UK, the US, and as well as Australia. So this Freeze and Seize Task Force is composed of the Commission, national contact points from each member states, Eurojust and Europol, as well as other EU agencies and bodies as necessary. So it's really important to understand that it coordinates actions by EU member states, Eurojust and Europol, and other agencies to seize, and where national laws provides for it, confiscates assets of Russian and Belarusian oligarchs. As you all know, the EU has so far adopted like a package of restrictive measures of sanctions, which include the listing of individual entities aiming to weaken Russia's military capabilities. That was the main purpose of the EU sanctions, EU restrictive measures. And just for you to keep it in mind, I think it's important in order to seize like the amount and the impact of these measures. With the latest package adopted on the 6th of October 2022, the EU sanctions now comprise asset freeze designation of 115 entities and 1,236 individuals. So the task force is also very active at international level. It's also in regular contact with Ukrainian authorities, including the new Ukrainian task force established after the appointment of the new Prosecutor General in Ukraine in July 2022. So now, like more linked with our subject today, which is about like opportunities to confiscate sanctioned asset, it is undeniable that there is a growing pressure to use frozen assets to finance the reconstruction of Ukraine. Like the willingness to use those confiscated assets to finance the reconstruction of Ukraine echoes the conclusion of the European Council on to the 22nd October 2022, which invite the Commission to present options in line with EU and international law aimed at using frozen assets to support Ukraine's reconstruction. And during his opening remarks to the International Experts Conference on Reconstruction, Recovery and Modernization of Ukraine on 25th October 2022, the Ukrainian President Volodymyr Zelensky called for using those frozen assets to finance the reconstruction of Ukraine. Like we all know that the World Bank issued a forecast to assess like the cost of the Ukraine reconstruction, which would be needed because of the war which happened like between February and May 2022, which thinks that the cost would be almost like 350 billion euros. So there is a need like for this money. And in that regard, the Commission put forward on the 25th of May a package to strengthen the confiscation framework in the EU. The package is composed of both a proposal to add the violation of EU restrictive measures to the list of EU crimes and a revision of the rules on asset recovery and confiscation, which kind of echo what was said by Ms. Nizeo, which will also contribute to the implementation of the EU restrictive measures. So focusing on the first one, as you know, currently there are over like 40 regimes of restrictive measures in place in the EU, and the rules criminalizing the violation of such measures vary across member states, so there is not a uniform approach to criminalize the violation of the EU restrictive measures. So the Commission followed like a two-step approach to end impunity for those violating union restrictive measures, including asset freezes and restrictions on financial and trade activities following Russia's invasion of Ukraine. I will detail more its legislative content during the second panel, but I think it was already like important to mention it right now. And so this two-step approach is the first one concerns like a proposal for a council decision identifying the violation of union restrictive measure as an area of serious crimes that meets the criteria specified in Article 831 of the TFU. So Article 831 of the TFU, for those who don't know, is the article which gives the legal basis for the EU to adopt directive, which would then be of a minimum harmonization of crimes which have to be serious crime with a cross-border nature, and that the EU has an added value to define an harmonized minimum standards. So once the Council decision is adopted, the Commission would put forward the proposal for a directive on which we're currently working on the violation of union restrictive measures as a second step. Following swift negotiation, the Council already reached a provisional agreement on the text on 29th of June, and the European Parliament gave its consent on the 7th of July 2022. The final adoption of the Council decision is expected to be in November, but it might evolve. So here what I can say as a preliminary comment on what the Free Senses Task Force is currently doing, and like to try to give like an EU approach of the issue that we're currently discussing right now.
Thank you very much, Pierre, for the overview of the activities or the areas where the task force is trying to help coordinate and harmonize the EU response. I would like to move on and give word to Tatiana, but I think we have lost her again, unfortunately. No, Tatiana, are you here?
Yes.
Perfect. Thank you so much for sticking with us. If you can, if you hear me, if you could elaborate a little bit on your previous argument on approaching sanctions from the security threat perspective. I'm aware that you have attempted to do so or are attempting to do so in Ukraine as well. So maybe you can give us some this way some example also to discuss in the second round. Tatiana, are you there? Might be easier. No, I think she dropped again.
It might be easier if she doesn't put the camera on.
Exactly. I was just about to. Okay, let's just wait a second. I think then we can just follow in the same order as we did in the first round. And if you could, each of you, react a little bit on this proposal. I mean, Maria, you did a little bit that you think it's actually feasible and that Switzerland or Italy are actually approaching sanctions in a similar way, or the legislation is set up to do so. And then also each of you, if you could pick on some of the examples that you already mentioned and go in a little bit more detail on some of the opportunities. For example, Sarah, you mentioned the presumption of money laundering legislation and some of the successes you have been having with it. That would be great. But I still don't see Tatiana, so maybe we just start with that, Sarah, if that's okay, actually.
Yes, that's okay. Yes, so perhaps quickly on the presumption of money laundering. So as I was saying, it was introduced into the French law in 2013. It is quite a recent mechanism, but it has been used in several cases involving money laundering of drug trafficking, for instance, that I will not develop here. But an important case in which the presumption of money laundering was used is the Rifat al-Assad case, So a case which is quite famous, where French justice convicted Rifat al-Assad, the uncle of Bashar al-Assad, for laundering of misappropriation of public funds. So Rifat al-Assad was convicted first in 2020. He appealed the decision, and then the decision was upheld twice by the Court of Appeal in 2021, and then by the Judicial Supreme Court in September 2022. And the justice used the presumption of money laundering for schemes found by investigators after 2013. Because this mechanism is not retroactive. It cannot apply, and this is the biggest limitation, it cannot apply to elements that happened before 2013, but for elements, facts that happened after, it is really useful. And so it's not the only mechanism that has been used in the Rifat al-Assad case that led to conviction, but it was an important one. And perhaps just to finish on this, and if you have any other question on presumption of money laundering, I'd be happy to answer it. But just to, I'd like Maria and Pierre mentioned the fact that, of course, sanctions are political, and I would like just to emphasize the fact that investigating the way how to improve sanction effectiveness is really important. But I think we should not forget the judicial path, whether it is civil or criminal. And just an example on that. So 10 years ago, we remember the Arab Spring. Sanctions were adopted. It was a different kind of sanction. It was anti-corruption sanction adopted at the EU level to facilitate the asset recovery and to denounce the misappropriation of public funds by the Mubarak and the Ben Ali's family. But as you mentioned it, Lucia, this sanction regime they have been lifted in 2021 for Egypt and a couple of days ago for Tunisia. And what remains now? No assets have been recovered, but in France, it's really not a success because I will develop. But in France, in parallel to the sanctions, French civil society organizations filed the same kind of criminal complaints we filed against the Russian oligarchs' assets. And 10 years after, when the sanctions have been lifted, the criminal investigation remains. So it's really not a success because only a handful of assets have been seized. We are talking about 10 to 15 million for Tunisia and approximately the same amount for Egypt. No enablers have been prosecuted, but still we have this framework and we can use it to ask for a conviction in France for money laundering or other related offenses. So I think it is really important not to forget the political aspect of sanctions. We all have it in mind right now, but I don't think it is in mind in every forum, and this is something we kind of struggle to emphasize when we speak to other actors. So I finish here, but this is something I wanted to emphasize.
Yeah, thank you so much. So definitely what echoes from your presentation is the need to start investigations, whether it is through trying to sort of push the law enforcement agencies or as a party, as a civil society organization. So maybe we could also come back to this. Maria, can I now pass on to you, please? Can you please unpick a little bit more of the opportunities? What do you see happening in the UK going forward?
Yeah, so I think that basically following up on what Sarah said, I think that it's very, very important that, you know, it's understood the sanctions can be a useful tool. As I said before, can be a useful tool in the bigger, you know, arsenal of tools, because they freeze the asset. They allow, for instance, for the tracing, you know, that's when you start, for instance, to have, if you manage to freeze the assets, it means that you have done some sort of investigation before to find those assets. So I can see the use of sanctions when talking about asset recovery. However, when we want to seize those assets and confiscate them, you know, permanent confiscation, it means that you are, you know, literally depriving somebody of somebody's property. So there needs to be that legal part, whether it's civil confiscation or whether it's criminal confiscation, there needs to be that process in place. Now, this does not mean that the fact that currently the mechanisms that we have at the legal level, especially in the UK, but it's not exclusively in the UK, the mechanisms that we have are not up to the task. That means that we can change potentially the legislation, Proceeds of Crime Act, as I said, and use sanctions as a useful stopgap in the meantime, as we, help our investigators to actually trace this money. I think that there are different approaches. One of the approaches is absolutely what Sarah just said. Presumption of money laundering is a very useful tool, potentially not completely applicable in the UK, but it does introduce some concepts such as full reverse burden of proof that it is worth exploring, and that other legislations around the world, such as, for instance, in Ireland, have been using successfully in asset recovery cases, not necessarily related to politicians or individuals, kleptocrats. I really hate that word, but kleptocrats. But they have proved to be useful, when in helping investigators in their cases, essentially. So full reverse burden of proof, absolutely. It is important to be clear in legislation about the basis upon which we are seeking to deprive the assets. So if I think in the UK, then that's definitely an element that we need to talk about, is what is the recoverable property? So what defines recoverable property? Amending that definition, or amending the unlawful conduct that is connected to the recoverable property, that is another way to talk about it. And the comment that I made before about national security is not related to sanctions per se. Italy and Switzerland, they're not doing it in relation to their sanction regimes. They're doing it in relation to their recovery of the proceeds regimes. So seeing, as recoverable property or unlawful conduct, anything that could be assets obtained through political patronage, or assets that can be made available to support an hostile regime. So still, we are talking about an amendment that is from a legal basis and requires a specific process and proceedings behind it. Because again, as Sarah said, and as I said a bit at the beginning, sanctions are a very political tool. They do grant a lot of reference to ministers and to politicians. And so it's very difficult to find a proper application that is going to be, equal for every country and for every individual. So regimes are often, motivated politically. So I think that's a second thing to remember. Generally speaking, full reverse burden of proof is worth exploring. Definition of unlawful conduct and recoverable property as well. Generally speaking, also maybe starting to have a sort of more targeted approach to what we mean by kleptocracy and by kleptocrats. So rather potentially than looking exclusively at a single action by each and every oligarch, looking at them as members of a kleptocracy, so an organized, corrupt organization. So once you had that sort of mentality, that bracketeering mentality, that potentially will lead you to more recovery. However, and this is, I'm going to finish with this, I think that amendments to legislation are very useful. However, they're not the solution exclusively if there is not proper resourcing of law enforcement agencies in the meantime. So most of the things that we're talked about, even if we change legislation, the starting point is asset tracing. If we don't have enough resources, if we don't have enough specialists, investigators to trace those assets and to be capable of providing evidence that there is a link to unlawful conduct, it doesn't really matter how strong your legislation is, it's not going to stand up in court and it's going to eventually fail. So there's not one thing that I really try to make everybody understand, especially, UK policymakers, they try to find a quick solution, a magic spell that would just seize all the assets. There is no quick solution. There is not one size fits all. It's several amendments in several parts, enforcement, legislation, and regulation as well. But this is a whole other conversation that we need to start.
Thank you very much, Maria. Let's try to go to Tatiana one more time. Tatiana, if you're with us, maybe try not to put your camera on, just to try to support the connection. But if you think that's fine, we can also do with camera. And can you please go back to your point about setting up sanctions not as anti-corruption tool, or not pursuing anti-corruption and sort of money from kleptocracy, but setting them up in reaction to the security threat, as you have done in Ukraine. Can you please describe how have you approached this in Ukraine?
So I'll move this camera because I either have connection or not. It doesn't have the middle ground. When we analyzed the situation in Ukraine, because Russian oligarchs had a lot of assets in Ukraine, our estimation is that that's like 2.5 billion euros of assets owned by Russian oligarchs are in Ukraine. We analyzed how we can target these assets, because many of them are of security interest. For instance, Russian oligarchs are owning Ukrainian electricity grid, which is quite a scene right now for everyone. And we have seen that most of these assets, I'm still there.
Yeah, we hear you. I think your camera is frozen, but we hear you. Or not anymore.
So I'm back.
Yeah.
I'm so sorry. So trying to say everything quickly. We have to go through security angle to that. And the only way to secure ourselves from Russian influence is to confiscate these assets as quickly as possible. That's why we added to the sanctions that they are used not only as a new tool, sanctions as confiscation of assets. So once the government decides that certain oligarchy is a security threat for Ukraine, the government has power to confiscate the assets through the court procedure.
Thank you so much. And can you just tell us a little bit more on this? So have you had any success with this?
So it took some time to establish, to adopt the law. The law was adopted in May. Then to establish their governmental capacity to trace the assets, to designate people, and then to go to court to confiscate. So far, we have only one successful case. The amount is not very big, but it was like probing case before the court, and I think in September there was a first decision. Their assets in question are corporate rights in some million or something dollars. But still, it was a probe. I hope that more will follow. We discussed this with their specialist on European Court of Human Rights, because Ukrainian court decisions are subject to review by ICHR. Of course, we will see what the court will say in a few years about the case, but so far we try to put as many checks and balances as possible to make this not like the country in war confiscates everything it wants, to make the procedure diligent as much as possible.
That's I think very, very promising to hear, and thank you so much for the example. I'll quickly hand over to Pierre for a quick sum up of perhaps if some of these promising legislative and policy areas, is this something you're hearing also in the Freeze and Seize task force?
I think it was really interesting what just said Tetiana, because we're really like in a close contact with the Ukrainian authorities, and we've heard a lot about this case of confiscation that happened through the High Anti-Corruption Court, and it was really interesting to hear from NTAC point of view. So I think what's really important to understand is that we need to make like first to understand like the situation we're in. So what is the situation we are in? There is like assets which are either frozen or blocked, and we need to distinguish the private assets from the public assets. Now, if we focus on the private Russian assets and the willingness to confiscate them, there is mainly like two main categories for confiscation. Either like a confiscation after a criminal offense, which is the one that is the most known, and as described Ms. Bramboeuf on front in the case that they are dealing with. It is possible, and we really have to encourage this feasibility, because it's the one with the strongest legal basis. As such, and the second main category is the confiscation not based on a criminal offense, and here there are many possibilities, but which all have their issues in terms of legal basis, in terms also of legal feasibility, but also political feasibility. So what we can discuss is the US model of civil forfeiture, and also their willingness to strengthen their confiscation framework, and notably their administrative confiscation framework. There is also the Canadian one, and currently there is a bill which is discussed by the Parliament in Canada over the possibility to implement a civil confiscation framework. And there is the one of Ukraine. Yes, it's absolutely true that Ukraine has stepped up its legal efforts by introducing and putting into practice a new mechanism for enabling more easily confiscation of Russian assets, and it has been done through a law adopted in May by the Ukrainian parliament, and it's really interesting, and it's examples that we're at least assessing and which can inspire us, but it's really like a preliminary stage, because there are a lot of issues linked to the legal basis that could be used, and also the legal feasibility of these different options, because as said by Tetiana, the current case that has been through the High Anti-Corruption Court in Ukraine might be subject to a revision, to a supervision by the European Court of Human Rights. So it's really something that we have to keep in mind. So now, if we focus on what the EU has done so far, so as I just said in my previous intervention, the EU had put forward a proposal for a new directive of the European Parliament and of the Council on asset recovery and confiscation, which really wants to strengthen the tools that member states can use in order to confiscate different assets. And then there is this future directive, once a council decision would have been adopted, in order to extend the list of EU crimes and cover the violation of restrictive measures by Article 83(1) of the TFEU. So that's the second main step. But as also I've said in my previous intervention, now the European Council, in its conclusion of the 21st and 22nd of October, called the Commission to assess all the possibilities that we have in order to confiscate frozen assets and use them for the reconstruction efforts. And we're currently assessing the different possibilities that are there, but it's very at preliminary stage, and it's because as you know, and we have to respect the rule of law and all its principles, and that's something that I think we should all be happy of. Even though sometimes it makes our life a bit more difficult, especially in that situation, but it's really something that we should not be ashamed of, and that we, on the opposite, we should be proud of. So I cannot say much about what the future would look like, but I think it's important for you to know that we're currently assessing all the different options, and we're really looking different examples from other area in the world.
Thank you so much, Pierre. And thank you to all the panelists. So we have heard now some of the ways the thinking and action is moving in the countries and also on the EU level. I would now like to give the space to our participants to ask any questions. If there are any, cognizant that we are coming to the end of the time that we have put for this meeting. So please do pose a question in the chat or just raise your hand directly. While you sort of do this, I would like to pose like a question on my side, and that is, you know, so what do we focus on next? So we have some tools. We would like to develop some new ones, you know, amend the existing legislation so it's more effective. What to do really? Like, do we focus on the resourcing, or it's really more about the legislation? What to prioritize as civil society and experts? Sarah, do you want to, or yeah, Maria? Sarah, okay.
As you, okay, Maria, okay, I start. No, I do think that that we should work both at the national level and at the regional, the European level, or even the international level with the RIPO task force, for instance. I think that we should really encourage initiatives in Ukraine or in France or in any other countries, whether they are strategic litigations or research or advocacy. But I also think that aim and the start, a state's alone initiative won't be enough. We need a multilateral initiative, or at least a regional one. So I do think that they should work together, and just as a civil society organizations representative, I really would love to see more litigation in other countries. I think it should. I really would like to witness a domino effect. I know that it is not possible in every jurisdiction. But I know that in jurisdictions such as Spain or Italy in a certain way, or Quebec as well, in Canada, it is possible for CSOs to have an active role in such litigation and to, yes, as I was saying at the beginning, to push the court door. We did it in France. It was not possible 50 years ago. We did not have any legal standing. Now we have one, and it changes the way we fight corruption. So yeah, I'd say every initiative together and strategic litigation as a potential avenue as well.
Thank you so much. Maria?
Yeah, just to add to what Sarah properly said, I think that it's also quite important to understand, you know, there are different conversations going on at the same time. So one side we have a matter of, you know, having our asset recovery frameworks as a whole, like generally speaking, better. Then we have the matter of sanctions, and especially anti-corruption sanctions as a tool. And then we have sanctions as it relates to the situation of Ukraine and asset recovery. So each and every one, they obviously require mechanisms that most of the times are the same, but they might answer a different goal. So even when we talk about recovery of assets, you know, from Ukraine, yeah, properly also said, you know, the assets are very different. So they will require different types of responses. So it's not really a matter of prioritizing one over the other. It's just understanding, well, starting to answer the question, what are we trying to achieve with these amendments? What is it that we want? And then once we finally answer that question, that's when we can talk about amending legislation or, you know, better resourcing. But before we need to answer that question, I don't think that everybody has really got a clue.
Thank you so much, Maria. Pierre, from the EU perspective?
Yeah, I think it was two like great intervention, like both from Sarah and Mariam, and really like I think here we're dealing like with different matters. So one is investigative powers and like investigative like way in order like to make sure that we are able to identify these assets. And I think what's doing Transparency International and working with investigative journalists is really interesting. It's really interesting because also it gives some methods that can be duplicated in different cases. And so here we're working on investigative tools, then working on the repression of those crimes that occur. And here we speak more about asset recovery and everything. And finally, the confiscation. Confiscation is really, it's really like a tough subject to be dealt at EU level, and really like I can assure that the Free Senses Task Force is really working tirelessly on this subject, and we'll really like looking forward to arrive with a solution on that matter. But as you know, like there are some difficulties, and we'll see how it goes.
Thank you. That's encouraging to hear. We are looking forward to reading some of the proposals. We have a question from the audience. James?
Yeah. Can you hear me okay?
Yeah, we can hear you and see you perfectly. Thank
Great.
you.
Thanks. I think some of you may already know me. I run the Asset Recovery Division for the United Nations Interregional Crime and Justice Research Institute. We're based in Brussels. We've been doing this for 27 years. So we have an idea of what works, what doesn't in conflicts and outside of conflicts, but notwithstanding that, the issues that have been and the creative solutions that have been mentioned in this conversation are encouraging. But there are two separate issues. One is how you deal with conflict-related confiscation, because as Maria said, what is our goal? I mean, our goal is hopefully not just to freeze, maybe for temporary political purposes, but and I think we all know that freezing without the real threat of confiscation is almost an empty threat, and does nothing more than freeze an asset where it's located and doesn't really do much beyond that. And I think there's been plenty of criticism that about the limitations of just freezing without the very real threat of confiscation. And I know Pierre probably knows that in several jurisdictions in the EU, there is only the ability to freeze and an inability within national legislation in several countries to actually confiscate the assets unless there's a criminal proceeding initiated, such as Spain and a couple other countries. Notwithstanding that, and I think as a response to that, this is what Pierre has mentioned, that creating an EU-wide directive that member states should consider violations of the restrictive measures as a criminal trigger to allow for a proceeding to go forward to confiscate assets. And I think all of us should get behind that and encourage the EU or any other stakeholders to get the EU member states to adopt that. The national security approach mentioned by Tatiana, I think is very innovative. And of course, we have to make sure that there's due process in those cases, but in times of conflict, that seems like that's one I haven't really heard of before, and I've been doing this for a while, but it seems plausible and useful, and so congratulations to the Ukrainians for developing that creative structure. As Tatiana knows, UNICRI is behind supporting the HAC, High Anti-Corruption Court, and the others involved in these processes. And if Tatiana feels we need to support any of these entities in furthering that mechanism and its successes, just let us know, Tatiana. The additional issue with respect to conflict-related confiscation, changing laws to allow for the presumption, whether it's of money laundering, or I would not go down the road of encouraging states to create a mechanism just for the presumption of money laundering. I would go down the road of encouraging states to, in certain circumstances, create certain limited circumstances to create a presumption of illicitly acquired assets. Because if we just talk about money laundering, then at the end of the day, and maybe what Maria might have been alluding to, at the end of the day, once there is a presumption created, the response should be that the defendant, or in most cases the beneficial owner, needs to come forth and prove that any of the assets acquired were legally acquired. And so that's where it would be useful. There's no real need to create a presumption of money laundering. There just needs to be a presumption of illicit acquisition, and which in many jurisdictions where there is civil confiscation, the state, such as in Ireland, which was mentioned, the state initially has to have some degree of burden to show that it's more likely than not that these particular assets are linked to some illicit activity, or perhaps in the legislation linked to a national security threat could be added on. Then once that initial 51% burden is met, then the burden shifts to the defendant or title holder or beneficial owner to come forth and prove that it was legally acquired. So that's in conflict-related situations.
You, James, can I just please ask you to wrap up slowly?
Yeah, sure.
And then we give a chance.
I know
to
it's taking
react.
a while, but I'm just trying to sum up here. The final issue is we should try to look beyond this conflict and figure out better ways to encourage, especially EU member states, to adopt civil confiscation or other non-penal forms of confiscating assets. And because conflicts will come and go, and we need to utilize this dynamic to encourage states to adopt longer-term mechanisms that will be useful in the recovery of assets in the long term. Thanks for your patience.
No, thank you so much for your comment. That was very fascinating, and I just want to make sure that we have a minute for the panelists to react. So I would just like to invite you to react to James' comment.
If I may, just now, I think it was really interesting, like comments made by James, and it's really important, like, to understand that obviously, like, there are some difference between EU member states, but there is what we're working on, at least at EU level, is tools that are going to be there to stay. Like, it's not tools that are only linked to the Ukrainian conflict. For example, when we're considering putting forward a directive which is going like to give some minimum harmonization of the crime of violation of EU restrictive measures, that is here to stay, not only like for the Ukrainian conflict, even though like it's obviously the one which is the most important for us right now. And we really have to show support to Ukraine. But yeah, what we're designing, at least now, is tools that may be used in the future. Like when we also put forward like a new directive on asset recovery, it's a directive that is going to stay. Like the only measures that the EU has been taking so far that might be lifted is the restrictive measures per se, if the war ends and everybody obviously would love that, but no, everything that we're designing are here to stay and here to make sure that confiscation are easier, but respecting also like the principles of the rule of law that we have to follow.
That's great to hear. Thank you. Sarah, please.
Yes, just in a couple of words. I mean, just to react on what James said about we don't need a presumption for money laundering, but we need a presumption for illicit funds. I say that a limit is that, for instance, with the Russian, we do not speak of public officials, where we can compare their official wages and their actual wealth. They can be, I mean, they are businessmen and they are really wealthy, and this is where we fall short when we try to prove the illicit. I mean, the difference with their, we cannot prove any difference with the wealth that they should have and their actual wealth. And this is where, with the presumption of money laundering, how it was drafted into within the French law, is that we do not focus on the money, but we focus on the scheme, on the financial or the judicial scheme that was put in place with the proxies, with the shell companies, etc. And the more complex it is, the easiest we can launch this presumption. So we can call it in a different way. Money laundering is a very complex offense, but I do think that we need something more than just the presumption of illicit funds or of unlawful wealth. That was just my comment, but thank you very much for it.
Maria, some final words from you?
Yes, thanks. I think that just to add to what Pierre and Sarah said, I think it's actually very important what James said at the beginning. You know, the reason behind the very existence of sanctions, at least from the beginning, was behavioral change. So there should be a sort of understanding that, you know, sanctions are going to be lifted at some point. However, in this situation, we're talking about individuals that should have had their assets confiscated a long time ago because, you know, of the underlying corruption that there was. So whatever mechanisms we're going to devise or come up with, whether it is new legislation or resourcing or whatever, they need to be capable of standing the test of time, for the simple fact that they're not the first kleptocrats that we're dealing with, and they're not going to be the last ones, unfortunately. I mean, if not, we would all be, hopefully, one day without a job. So I would like for people to also, you know, think of sanctions, but, you know, put them a bit on the side and think about the individuals and the origin of their wealth. I know that obviously sanctions are very quick solutions, but they're not good. This is not the first crisis that we're seeing in terms of kleptocracy. We're seeing Libya, we're seeing Tunisia, we're seeing loads of them, and there's going to be much more. So any mechanisms definitely needs to stand the test of time, and sanctions need to do their foreign policy work, which is to change behavior in the meantime.
Thank you so much for the wrap up. Unfortunately, we don't have Tatiana any longer with us. I think she's continuing having problems with electricity, but I think it is really interesting how Ukraine itself is trying to confiscate Russian assets, and there is more information about this also on ANTAC website. So if you're interested, I would encourage you to go and read there. And thank you so much to our great panelists. Thank you so much for our participants and bearing it with us. I see one more comment in the chat from James towards Pierre. offering the UN's assistance in case needed in persuading stakeholders in the European Parliament or other entities. So I think that's very much appreciated. And I hope we will continue this conversation again in the future. Thank you so much.
Thank you very much.
Bye-bye.
Thank you very much. Bye.
Thanks a lot. Bye-bye.